Now, can an employer reject a sick note issued by a traditional healer? The law may allow a company to refuse it as proof for paid sick leave, but dismissing the underlying cultural belief, I think, could still lead to an unfair labor decision. The issue has been sharpened by the incapacity tribunal involving Judge 𝗘𝗺𝗃𝗃𝗀𝗃𝗃, where medical evidence and traditional beliefs point in a very different direction. It really is a big South African issue. I want to talk to Jonathan Goldberg now, who is chairman of Global Business Solutions. Such an interesting issue, Jonathan. Welcome to the program. Can an employer legally reject then a traditional healer's sick note?
Hi, Jeremy, and hello to your listeners. So there are two things we got to just understand. One is payment for the sick note. So the payment for the sick note is really regulated by the Basic Conditions of Employment Act or by any agreement you might have, collective agreement that you might have with your employees. So let's take the Basic Conditions of Employment Act. At the moment, it only recognizes medical practitioners. So the issue around traditional healers' notes, and again, it's defined as herbalists and traditional birth attendants and traditional healers, is regulated by the published Traditional Healers Practitioners Act, which is published in 2024. But that has not been affected yet. So there's an intention to include these traditional healers based on registration and a whole lot of compliance. But that's not gone through yet, and mainly because there have been objections from traditional healers about this act. So that's still in debate. So currently, only medical practitioners that are registered and accredited, that includes some nurses that have additional qualifications, they can issue these notes, and these notes then be paid by the employer.
It does, though, create a tricky situation, difficult for an employer then to avoid unfairly discriminating against an employee's cultural belief.
So there are two issues. So that's in respect of payment, whether you have to pay. But the 𝗘𝗺𝗃𝗃𝗃𝗃 matter, a labor court matter, really emphasized the issue around a cook who wanted to take some time off to go to his traditional healer and to go through that exercise, where the employer could have given him the time off but refused. That time would have been no work, no pay generally. So it's a different issue as to whether you need to accommodate a person's traditional beliefs or a person's traditional note. Whether you have to pay for it, of course, is the question regulated currently by the BCEA, Basic Conditions of Employment Act, which of course will change when the Traditional Healers Health Practitioners Act comes out. But currently you would still have to consider whether Johnny or Jeremy could take the time off and go through a traditional healer program, as an example, to heal me if I believe that was going to heal me, and give me the time off. That's an incapacity decision. Can the employer allow Johnny to go off without any particular pay for that period of 2 months to go through that particular program? That's the issue. And the 𝗘𝗺𝗃𝗃𝗃𝗃 matter says, well, you've got to recognize my beliefs. And if you can get a temp in or other people can cope, then you should allow me the time off, because I'll come back. I'll come back a better person, healed, and be able to continue to cook in your establishment.
Am I correct in thinking that you've also identified the bigger problem, not traditional healing, but more the state's failure to establish a functioning practitioner register?
The state's tried, Jeremy, but of course, again, practitioners have to be registered with the appropriate statutory body. And again, that requires the tax net and the registration net, et cetera, et cetera. And of course, some people don't want to participate in that particular structure. So there are some objections to the way the current Traditional Health Practitioners Act has been positioned. But the point is, it has to come out. It will come out. And I think these people that are registered and accredited by a professional body will then be able to issue these notes in terms of the Basic Conditions of Employment Act.
But there's a conundrum, because until that register exists, it's going to be difficult, Jonathan, for an employer then to establish whether the healer is genuine, qualified, or, as I think you're intimating, even identifiable.
And then effectively, from a payment perspective, you don't have to pay, but you still have to consider whether I could take the time off and your establishment could accommodate me. Now, remember, in South African labor law, many, many companies have recognized traditional healers. So they're part of the 30 or 36 days in a 3-year cycle, and they acknowledge these particular traditional healers' notes by a collective agreement. But the law is still catching up with that. And again, I think for the law to compel employers to pay, there has to be some type of accreditation, some type of registration. And of course, for all of us South Africans, some recognition that these are accredited businesses that are paying their taxes, as an example.
So as we have this discussion now with things fairly opaque, where does an employer draw the line between respectful accommodation and an absence that the business can no longer sustain?
I think it's a real factual question based on the job. And I think I always say that in terms of South African law, correctly so, the Basic Condition Employment Act, we have to give a female employee who has a child, was the 𝗦𝗶𝗰𝗸 Constitutional Court judgment affects that too, but we have to give 4 months off. So generally the tolerance for me is always around about 4 months, because no matter what the position is, the person who gives birth can get 4 months off. So we tolerate that in terms of the law. So I would imagine that most organizations who have the request would have to have some type of tolerance around 3 to 4 months before they could say, we can't tolerate this anymore, we can't keep you employed. That would be my guideline. Again, I've already alluded to the payment situation, and that's from organization to organization as to whether you want to extend your payment beyond the Basic Conditions of Employment Act. But I think we've got to have a bit more tolerance in respect of people who have the belief that they need to go through a program to heal them, as an example. And if that's a couple of months, I think most organizations can tolerate that.
So if that's the case, then what should every employer now put into a sick leave and incapacity policy to, Jonathan, avoid any kind of discrimination and abuse?
I think the fact that requests for time off will be considered based on the operational requirements of the business. And I think here you've got to have an open mind in respect of looking at the request and looking at the operational requirements and trying to accommodate the person. Because people have beliefs, like I have the belief that a specialist might cure me. Other people have different beliefs, and those beliefs, as we've seen in medical science, are very important in respect of healing a particular person. Your beliefs are very important in respect of your recovery.
Jonathan Goldberg, thank you very much indeed. You're the chairman of Global Business Solutions.